Let it be fifth, my lord. In case it spills over, it can go to ninth. And we hope, my lord, they will make
Something
some,
should
state will make some alternative
something
arrangement.
should be done.
Otherwise,
Yeah, we don't have
we'll
the
be prejudiced,
clear
man.
mandates as yet. So some accommodation is required, expect. We'll try to, settle it by fifth. It's
After
everything.
the new government.
Yes. The government has come now they're taking some time. They're saying, let's just, some accommodation, we should request your lordships.
Then fifth
Fifth.
January.
Deep level.
Back to mention item number 13, Lordship. Affidavit has been filed, Lordship. Affidavit may be called, Lordship.
Hmm?
Affidavit, I want to call it affidavit, Lordship.
You filed affidavit
Yes, Lordship.
this morning.
Lordship. Lordship, it will come.
May I please, your lordship, matter relating to writ appeal or relating to tender, my lord. So let the matter come tomorrow, my lord. There is an urgency, my lord.
What urgent? What urgency?
Actually, my lord, interim was not granted, my lord. That's why I come before your lordship.
So there's no urgency involved.
Let the matter come tomorrow, my lord.
We'll have it on Thursday,
Thursday.
21st.
Obliged.
May I please, Lord? I beg to mention item number 23. In this case, I am appearing for the respondent, Lordship. We are having some, Mr. Endeka is having some personal difficulty today, Lordship.
Have you informed the
Yes,
petitioner?
yes, I have taken the consent.
Who's appearing for petitioner? For the appellant.
Appellant,
You have taken the consent?
yes,
Okay, and request made on behalf of Mr. Ndeka, Leonard, counsel for
respondent.
respondent,
I am M. Gogoi, Lord.
for the respondent. When do you want?
After vacation, Lord.
Yes. On 18th.
Obliged.
May I please, your lordship.
Hmm.
Therefore, listing a matter by Thursday, lordship, eviction matter, lordship. Writ appeal, lordship, eviction matter, learned single judge, lordship, given some time frame, lordship, this time will be end on this week, lordship, regarding eviction matter. Obliged.
May I be lordship, regarding the item number 19, my lord. This matter may be taken in another bench, my lord. Because in the repetition, my lord, were a peer member in this matter.
Appeared in the matter?
Yes, my lord. Item number 19.
Item 19.
Hima Haso Council, my lord.
Okay, list this case. If any other bench without one of us, you put within bracket justice. Kaushik Goswami.
My lord. Obliged.
May it please, your lordship, I beg to mention for listing of a writ appeal for day after tomorrow. On
What is the urgency? involved?
urgency, the wrong fixation of salary.
Hmm.
And it was the appellant was aggrieved by the single writ petition.
There's there's no urgency involved with this wrong fixation.
Lordship.
We'll have it in January.
Lordship.
January.
Obliged.
May I please, your lordship, I beg to mention for listing of contempt case after vacation.
Yeah.
Any date may be given, lordship.
8.
Much obliged.
Item 1 to 3 for motion.
Two items. Two, my lord, they have tagged with, my lord, possibly item number 1.
These all 1 and 2, my lord. These are connected with the contempt petition item number 3, my lord. There was a suo motu PIL wherein directions were passed for eviction of encroachers to reduce human elephant conflict and preservation of forest, my lord. And for the forest department, we have taken steps, my lord.
My lord, contempt petition will take up the first, my lord.
I am addressing the contempt.
Give the content.
Contempt petition.
Everyone is followed. এরকম থাকিলে
So, like to argue today, my more bottom, there is a procedure, you should follow the procedure.
You are praying for revenue?
No,
forest.
forest.
No, my lord, what happened in this case, my lord? There is a PIL file before this honorable court regarding encroachment in forest land in Goalpara. And as a result, there is a conflict, there is human elephant conflict. Several elephants died because their corridor and their land had been occupied by some illegal encroacher, my lord. Then this PIL was filed. In that PIL, their order was passed. Direct the government to take some remedial measure immediately, including enforcement fee, land. They have admitted that more than 50% of the, my lord, forest land has been occupied by somebody, my lord. So they are asked to, my lord, clear that, my lord, and human elephant conflict, just to reduce the human elephant conflict, you make a task force, you take steps appropriately, remedial measure, so that, my lord, human elephant conflict will be less and forest land will be free from the encroachment. So that direction was not been complied with by the in respect of that forest land, my lord. Then this suo motu contempt has been issued. So now, my lord, in contempt petition, my lord, they have said that we are going to take action, but that is only in papers, my lord. Till today, my lord, even, my lord, last month also, my lord, I have seen, my lord, human elephant conflict is going on and enforcement is still there, my lord. So that is the case, my lord.
And I have given those documents, man. It clearly indicates the action we have taken. This is communication written to the DC. It indicates, my lord, the extent of eviction drive undertaken and also the proposed eviction to be taken out from 10 January, 4th of January to 10 January, perhaps. My lords, we are complying with the orders, but there's a human facet to it. Lots of people are, my lord, are residing encroachers, my lord. So to remove that, my lord, we have to seek help from the administration.
The administration not
Is helping,
cooperating?
my lord. They're helping out, my lord. So we are taking phase wise, my lord. It's been undertaken, my lord. Normally, my lord, this winter, my lord, if we go for eviction, my lord, we again, my lord, brought on press and TV everywhere, my lord, that we are doing it for, my lord, inhumanly, my lord, is being dealt with, my lord. These are the phases, my lord. These are being looked into, so phase wise this is being carried out, my lord.
So let them file a status report, what action they have taken.
Two numbers of eviction has been.
Two eviction they have already taken out.
As per my staff.
And now, my lord, 4 under yes. This is the same communication, my lord, but this is.
This is from Deputy Commissioner.
We'll bring that on record, my lord.
Same.
Same, my lord. That is.
Two numbers of eviction.
Mohan Chodo type it.
এই তহঁতি প্ৰথমতে লিষ্টখন উলিয়াই কিমান মানুহ আছে ডেফিনেটলি একেদিনাই কৰিব নোৱাৰো কিন্তু বাট সেইকাৰণে
You are saying your tentative dates are 2nd to 10th of January.
My lord. These are the dates.
Are you going to do it or?
Yes, we are going to do it. We are going to do it.
Let us see.
My lord, they let them file, my lord, time to time, they file a status report. These are the action we have taken as per the High Court direction. Then, my lord, there will be no contempt, my lord.
But Mr. T.J. Mahanda, Learned Standing Council, in the contempt. Stop. Mr. What's his name?
I am for the forest management, D. Gogoi, man.
Mr. D. Gogoi,
Standing Council Forest.
Learned Standing Council Forest Department has produced a communication dated 4th December 2023. 14th December 2023. Written by the Divisional Forest Officer within bracket T, Golpara Division, Golpara, and addressed to the District Commissioner, Golpara, on the subject of proposed evictions under Golpara Forest Division. Stop. He submits that the department is planning to conduct eviction drive at the Kumarkari RF, huh?
Kumarkhali, right?
RF Lakhipur range,
Lakhipuram.
comma, Nalanka Bahar RF, Golbara Sada range, comma, Pancharatna RF, comma, Kolbara Sada range, and Kanyakuchi RF, Rangjuli range, Rangjuli, between 2nd of January to 10th of January 2024. Stop. Para. The communication dated 14 December 2023 is placed on record. Stop. The Forest Department is directed to file a detailed affidavit with regard to the status after the eviction drive is carried out between 2nd January to 10th January 2024. Stop. When can you file your affidavit?
By 18th or 15th, or 18th, my lord,
We list it on 18th.
my lord, my lord.
List the matter, list these matters again on 18th of January.
Deeply.
Public.
For admission, item 7. My lord, I am representing in item number 1, my lord.
1 minute,
Uh,
1 minute.
In that case also, my lord, item 1, my lord. There was an order dated 1/12.
No, I passed the order in the contempt. We'll
Well-
take it up on 18th.
My lord.
But in this matter, the authorities, they are coming up today with the records, you know. No, I need some time, you know, for filing of the affidavit, you know. The instructions I have sought, they are coming up with the records today, you know.
Okay. Your good name, please?
Binong, your lordship. Binong Rongpal.
Have Mr. B. Rongba,
Yes.
learned counsel for the petition.
Your
Mr.
lordship, may I prefer a specific date because they are taking time.
Being not
Yes.
the senior governor, is allowed another?
But Lachima, give us 1 week time, let it be on 6th or 7th, you know,
Another one
the
to
affidavit in
file-
the meantime.
To file affidavit. List on 10th January.
Look, come on, look.
Item 8 to 12.
Lordship, matter may be passed over for the day, Lordship.
For the day,
Yes, Lordship.
on request of,
S.A. Khalifa,
no, you are appearing on behalf of,
KDV.
okay, on request made on behalf of MSK Devi,
And for item number 9, 10, 11, and 12. Lordship.
Learned Counsel appearing in writ appeal number 171 of 2023.
I'm
List-
appearing for finance.
List the matter when?
After deification,
On 22nd January.
27. Item 30.
My lord, they provided the conditions, my lord, since
Affidavit
One
has
was
not
just-
yet come, Lordship.
I've got a copy of the affidavit, I'll provide.
Affidavit has come,
No, Lordship. I think
affidavit. Will you call for the affidavit this morning? You have called. Affidavit has not come yet.
it will come, can it be after half an hour, Lordship? It will come,
They put the same condition. I'll provide them.
not the same condition, Lordship. I can take.
After some time.
After time.
What will do?
Item 14.
Hello, we are for the respondent, I am for the respondent number 6, ma'am.
None appears for the appellant. Mr. TJ Mandal and senior counsel appears on behalf of respond number 6.
And my Leonard Pen appearing, we have to.
T. Sharma, Leonard.
Please come.
Oh, you have come. Cancel it.
After 10 minutes, you will go.
Why?
I am hurrying now, some collection, some books you will go. 10 minutes you will go. Not to be here.
10 minutes question.
Item 24 from supplementary list.
May it please your lordship. But in this case, I have challenged the order dated 13/12/23 passed by the Honorable Single Judge, my lord.
Page.
The each page number, my lord, lordship will find page 244. It starts from page 46 to 46.
IA.
IA, my lord, and by this IA, the entire writ petition also has been disposed of with certain directions, my lord. But can I place your lordship the little fact of this case, my lord?
Yes, proceed.
My lord, just let me take brief background of this case, my lord. My lord, this particular fishery, this is number 2, Sutia fishery, was settled with reservoir number 4. Lordship, kindly notice reservoir number 4 in 2013. Yesterday you have given the copy.
Only it has been served to government, deputy commissioner.
Yesterday, my lord. It was given, my information was given yesterday, my
It
lord.
has been served to government.
No, government the delivery yesterday, on Saturday, but yesterday that been served, my lord.
Let it
To their
be
office, my
served,
lord.
let it be fixed on tomorrow. Okay.
Or maybe 2 o'clock, let me give the copy to him, my lord. There's some urgency, man. 2 o'clock, I will give him the copy. I verified in the morning, I gave the copy myself, go and give it to the government council, my lord.
No, government council is.
No, not government council, fishery. It was given to him on Friday, Saturday. But so far you in concern.
Whatever it is.
Anyway, my lord,
Receive
with-
the copy, there's no need to.
Yes,
talk and
let it
for-
come at 2 o'clock, my lord. I'm giving the copy right now.
Let it be tomorrow. Let it be tomorrow.
2 o'clock, let it come.
Okay.
25.
Right, your lordship. So this inter-court of appeal is filed against his judgment and order dated 12/12/2023. Actually, the brief facts of the case is that, lordship, the petitioner was appointed initially as a graduate teacher in the year 2013. Now he is continuing and drawing graduate scale also. Now, after the retirement of the headmaster of that particular school, the petitioner or appellant was allowed to hold the charge of the school. That was done on 12th of September 2022. That lordship will find at page, my insertive order, annexure 1, page 40. Annexure 1, page 40. 12th of September 2022. My qualification is MSc B.Ed. Now, thereafter, lordship, the my petitioner school is a base school. The respondent number 4 school is amalgamated. That amalgamation order, lordship will find it annexure 2, page 41. 17th of June 2023. Now, at the relevant point of time also, at the time of amalgamation, I was continuing or discharging service as an in-charge headmaster lodge. Now, suddenly the impugn order passed on 5th of August 2023, annexure 3, page 43, whereby I have been replaced by an unqualified teacher lodge. He is not having B.Ed qualification, and it is admitted position of the case lordship. The respondent number 4 is not having the B.Ed qualification.
You
Then-
also don't have the B.Ed, isn't
I
it?
have a B.Ed, MSc B.Ed. The insertive order itself shows page 40, MSc B.Ed. Page 40, annexure 1.
Okay.
So the rule at all along, or this is a settled position of law, or this honorable court held on many occasions, Lordship, that to hold the charge of a headmaster in a provincialized school, the candidate should acquire the mandatory requirement of the provision of Rule 14(2). That is, B.Ed is a mandatory qualification. Now, without having B.Ed qualification, I have been replaced, and ultimately I put to challenge this order 5th of August 2023. Now, before that, Lordship, I'm coming to the impugned judgment, Lordship. The petitioner school earlier, respondent number school, earlier he was serving in a Vansar High School. So when the Vansar High School was provincialized in the year 1/1/2013, the service of the respondent number 4 is provincialized as a headmaster, Lordship, although he is not having qualification. And that provincialization order was passed under the 2011 Act. Now, 4(3) of the 2011 Act say, if some teachers is not having the academic or professional qualification, then he should acquire that qualification within a period of 5 years. But here it is a case, although the service of the respondent number 4 is provincialized as a headmaster, but at no point of time he acquired the qualification of B.Ed, Lordship. So ultimately, this honorable court held that, Lordship, since the respondent number 4, Lordship will find the impugned judgment, page 99. Page 99. Paragraph 7 and 8 is the submission of the appellant. May I read what was the submission? Paragraph 7, Lordship, 101. May I read, Lordship?
Yes.
Paragraph 7, page 101. Mr. A. for the petitioner submits that the respondent number 4 is not eligible to hold the charge of the post of headmaster of the said school in view of the fact that he does not possess the educational qualifications mandated under the provisions of the Assam Secondary Education Provincial School Service Rules 2018, more particularly Rule 14A thereof, inasmuch as the respondent number 4 admittedly does not possess a B.Ed qualification. The learned counsel for the petitioner contends that the petitioner, having not satisfied the eligibility conditions requisite for recruitment to the post of headmaster of a high school as mandated under Rule 14(2)(a), he is also not entitled to be permitted to hold the charge of the said post, and in this connection relies upon the case of Jagannath Pegu versus State of so, wherein it has been held by this court that even for holding a post on in-charge basis, the incumbent must satisfy the eligibility conditions mandated for recruitment to the post in question on regular basis. Para 8, Mr. So by referring the provisions of the order of amalgamation, more particularly clause 8 thereof, submits that the petitioner, being the senior-most headmaster of the school, should be permitted to continue to hold the charge of the said post, and the respondent number 4, in addition to being not eligible to hold the post on regular basis, is also junior to him. Mr. Eka further submits that the order of 5/8/2023 has the effect of replacing an ad hoc by another ad hoc, inasmuch as the petitioner is the first instance was permitted to hold the charge of the post of headmaster, High Order dated 12/9/2022. And the same was an ad hoc measure, and he, having been appointed on ad hoc basis, he could not have been appointed by another ad hoc appointee. Mr. Eka praised that post of headmaster of Tamargaon High School be filled up on regular basis until such time he be permitted to hold the post on in-charge basis. Para 9, per contra, Mrs. B. Chaudhary, learned counsel representing the respondent 4, in a short and concise argument has submitted that the respondent number 4 is the regular headmaster of Nobhanga High School, and his service were provincialized as headmaster of the said school. The respondent number 4 was also authorized the scale of pay to the post of headmaster pursuant to the amalgamation of the school Nobhanga High School with Tamargaon Private High School. The status of the respondent number 4 as an incumbent in the cadre of headmaster was not altered, and he was inducted into the amalgamated school as a headmaster with the authorized scale of pay to the post of headmaster. Referring to clause 8 of the order dated 17/6/2023, the order of amalgamation, it is the contention of Mrs. B. Chaudhary that the respondent number 4 being in the cadre of headmaster, the case of respondent number 4 cannot be compared with that of the petitioner, who continue to be the cadre of the graduate teacher. It is the contention of Mrs. B. Chaudhary that the provision of clause 8 of the said order dated 17/6/2023 and also similar provisions in the scheme, Shiksha Kshetra scheme would take place only in the event of two incumbents involved are both holding the post of headmaster and of the or principal on regular basis. The said provision of clause 8 according to her would have no application in the present case. Now ultimately, see, the paragraph 16, the finding of the court. This now leads me, page 106, paragraph 16. This now leads me to consider the contention raised by the petitioner that the respondent number 4 is not eligible to hold the post of headmaster in view of the fact that he does not possess the requisite educational qualification mandated under section 14(2)(a) of 2018 rules for the said post. The said rules mandated that a person to hold the post of headmaster must have a graduate degree along with BTBA degree. Sorry. It is an admitted position that the respondent 4 does not have a BA degree. However, this is important, Lordship. What is noticeable is that the service of the petitioner was provincialized with effect from 1/1/2013 by the departmental authorities. Actually, it should be respondent 4 instead of petitioner. Departmental authorities filed an order dated 18/11/2023 as a headmaster, and there was no condition whatsoever attached to such provincialization affected in the case of the petitioner. The order dated 18/11/23 is not under challenge in any proceeding and same has attained finality. As such, respondent number 4 is for all intent and purpose the only incumbent in the cadre of headmaster in Tamargaon Tribal High School. Now, Lordship may have the educational manual. What the section 4(3), although I have raised that objection, that was not at all considered by the learned single judge. Lordship will find education manual the blue color. What I'm trying to say, Lordship, the provincialization order of the respondent number 4 is a conditional one. The act itself provides. Lordship may come to page, directly come to page 655. This is Act Assam Bhansari Educational Institutions Provincialization of Services Act 2011. 4(3), may I read, Lordship? The services of a teaching or non-teaching employee in a Bhansari educational institution sorry, up to the higher secondary level shall be considered for provincial only if they have their requisite academic and professional qualification. Now, for the Lordship, the academic qualification is BA, BSc, BCom, and professional qualification is BEd or MEd, Master of Education. Professional qualification prescribed by the relevant rules at the time of the initial appointment. In case of employees of a degree college, they must have acquired, we can skip this order, provided, this is important, Lordship, provided that if an employee is required to acquire any prescribed academic or professional qualifications, services of such employee may be considered for provincialization if otherwise eligible. Now, here also, the respondent number 4 is otherwise eligible, and that is why his service was provincialized, but with a condition. Now, what is that condition, Lordship? But in such case, the provincialization would be subject to acquisition of such prescribed qualification within a period of 5 years from the date of coming into force of this act. Now, this act come on 5th of September 2013. Sorry, 11. So from that 2011, September 2011, by September 2016, the respondent number 4 ought to have acquired the requisite qualification to hold the post of headmaster on regular basis or in charge basis. Now, if failing which, what will be happen? That is also prescribed, Lordship. For 5 years from the date of coming into force of this act, and during this intervening period, he may continue to work under the existing terms and conditions which he was working until his services are provincialized. In case of his failure to acquire the required academic or professional qualifications within the stipulated period, his service shall stand terminated with effect from the date of expiry of stipulated period of 5 years. So here it is a case, the respondent number 4 service was provincialized as a regular headmaster, although he is not having the requisite qualification of BA. But the Provincialization Act itself provides those teachers should acquire the requisite qualification within a period of 5 years, and failing which he shall be terminated. That means his substantive post was graduate teacher. Since at the time of provincialization of the school, he holding the charge of the headmaster, that is why his service was provincialized as a regular headmaster. But since by applying this section 4(3), since he failed to acquire this qualification, his service ought to be demoted to the post of graduate teacher. And this aspect of the law, Lordship, these learned singulars have not considered at all. And that is number one. Secondly, Lordship, this rule 14(2), already I have read out, Lordship. The rule 14(2) is even for insert or regular basis, one should acquire the mandatory prescribed qualification for the post of headmaster. Then another aspect is that rule 24(3), Lordship, may come to. Now, what happened if the school is amalgamated? Then how the seniority will be determined? Lordship, may come to page. This aspect is also not considered, Lordship. Page number 42. Assam Secondary Education Provincialized School Rules 2018. 42. This is rule 24(3). The seniority of a member of the service in a cadre. Here is a cadre of a graduate teacher who joins in a school otherwise than by direct recruitment. Here it is not a case of direct recruitment. That is transfer or otherwise. Here, Lordship, otherwise comprise the amalgamation or merger, Lordship. Now, if somebody, Lordship, join by otherwise, then how the seniority will be determined? Shall be determined as per date of joining in the school in the concerned cadre. Now, this petitioner came to my school on 17th of June 2023. Now, by applying this provision of rule 24(3), the seniority of the respondent number 4 should be counted from the date of 17/6/2023.
No, that one, I think that what they have a office memorandum is there, isn't the Majumdar?
But
With
No.
regard to amalgamation.
Amalgamation, Shiksha Kshetra scheme is there, entire scheme is there.
now, maybe there, but the provision itself says how seniority will be determined. So, from the date of joining in the base school, his seniority will be joined. Here, Lordship, that is why my respectful submission is that in view of this section 4(3) of the 2011 Act, the rule 14(2), the requirement of BA, and rule 24(3), the respondent number 4 is not eligible to hold the post of headmaster on in charge basis. But that was not considered, Lordship. And the after, Lordship, the stripping down the Act of 2011. Now, what will happen to those provincialization order which was done under the 2011 Act? So, after September 2016, when the government promulgated the new Provincialization Act of 2017, the section 24 itself authorized the authority to review such order, Lordship, if there is some discrepancy. And that was also not that. And the Honorable Single Judge also held that the clause 8 is not at all applicable in respect of the resolution number 4. If that is, we admit or true accepted, Lordship, then the impugn order itself is wrong. Because by the inserting the clause 8, the regular headmaster is demoted to the post of in-charge headmaster, Lord. That is why the learned single judge held that the clause 8 is not applicable. Now, if clause 8 is not applicable, by inserting the clause, I have been replaced. That order itself is wrong. That order, the authority till date has not reviewed that order. Lordship, kindly come the impugn order, Lordship. Impugn order lordship will find at page 43. Very cryptic order lordship. Here and there lordship, witness lordship, they are relying on lordship view of the standing count. No, that he has no any force lordship. It has no any binding force. Annexure 3, page 43. Read the proposal. Now proposal is submitted by the respondent for himself. That was submitted by the inspector of schools, Lakhimpur, hide letter that sense. On perusal of the above proposal, it appears that the Navbhanga High School was provincialized with FCOM 1113. The service of Sri Dilip Kumar Bharlua was provincialized as headmaster in the school. Subsequently, he has been serving as regular headmaster in the school since provincialization. On the other hand, Navbhanga High School has been merged with Tamargaon Tribal High School under Lakhimpur so dated 7 so. As per clause 15A of the GOM office memorandum dated so, did and regular headmaster of Navbhanga High School is the ex officio headmaster Tamargaon Tribal High School. Now, ex officio headmaster white prayer petition dated even prayed for allowing him to exercise the DD role in the Tamargaon Tribal High School. Now, this Tamargaon Tribal High School is the base school lordship, the appellate school lordship. Subsequently, inspector of schools dated 14/7/23 submitted proposal along with the seniority showing name of the existing headmaster in charge of Tamargaon school and the name of so and so. In this regard, the opinion. So I am skipping this period. In view of above, Dilip Kumar Bharlua, ex officio headmaster of Tamargaon High School, is hereby temporarily allowed to hold the charge of the headmaster of the same school. Now, the learned singular held that the particular clause of the office memorandum by which the amalgamation order was given effect to, it is not applicable in respect of respondent number 4. If that is so, lordship, then the order itself is wrong. Then it requires some review, lordship, by the concerned authority. So these aspects are not at all considered, lordship, by the learned singular. Ultimately, my prayer was rejected. In paragraph 15 in the judgment page, lordship, page 105, lordship, the views of the Honorable Learned Singular, lordship. In 14, they have quoted the relevant portion. 15, in the understanding of this court, the said provision of clause 8 has got no application. In the fact, emanating in the present proceeding, inasmuch as it is only the respondent number 4, he is the regular incumbent in the cadre of headmaster, and consequent upon amalgamation of the two schools, the petitioner, it should be respondent number 4, was shown to be holding the post headmaster with the scale of pay attached thereto in the amalgamated school lot. So therefore, lordship, if the clause is not at all applicable, and by inserting the provisions of section 4.3, rule 24.3 and 12.4, lordship, the views taken by the learned single judge require some review, lord. And I am still holding the charge, lordship, till dead, lord. This is my submission.
You're still holding charge?
Yes, yes. This order was passed on 12th of December. Today is 19th. I'm still holding it. And initially also there is a status quo order when I wrote the writ petition, lord. I just continue.
Majumdar,
Subject to reply.
a little handicap the file. The lordship will find that the reference at para 14 of the judgment, why the learned single judge has said that clause 8 would not be applicable has been elaborated. Clause 8 comes into play only when there are two headmasters in the two schools under amalgamation. It is at that point of time, the senior most headmaster would become the de facto headmaster. In the present case, there is one headmaster and a graduate. There are no two headmasters. And it is in that context, the learned single judge says, there is no question of a seniority between the headmasters to be determined by me. If lordship would have paragraph 14, my lord, the provision of said clause act on a close reading would indicate that the same would come into operation when there are two principals or two headmasters coming into existence in an amalgamated school consequent upon the amalgamation of the two schools. It is under this circumstance that the provision of clause 8 mandates that the senior-most among the principals or headmaster would be the principal or headmaster of the school, and the other would be denoted as the ex officio principal or headmaster, with the post personal to him, and he shall continue to get the scale in the existing status till retirement or posting elsewhere. In the understanding of this code, the said provision has got no application in the fact emanating in the present proceeding, in as much as it is only the respondent number 4 who is the regular incumbent in a headmaster. So the petitioner writ appellant, not being a regular headmaster or even an in-charge headmaster when this amalgamation took place, clause 8 would not be applicable is a correct finding in my humble submission.
And what about the requirements under the rules of 2018?
My lord, rules of 2018 where B.Ed is one of the qualifications required. There have been headmasters in non-amalgamated schools who did not have B.Ed and were promoted as headmasters at some point of time. Shiksha Kshetra scheme makes it, clarifies it that a person who was holding the post of a headmaster in an amalgamated school to become a headmaster, he need not have that particular qualification, because he is not in a position to attain that qualification at this point of time. In the present case, this person was holding the post of a regular headmaster when he was provincialized, with or without the B.Ed degree. Not a single judge has observed that provincialization order as an headmaster or his continuing in the service has not been put under challenge by the writ petitioner. In the case presented by the writ petitioner before the learned single judge, what was argued and what was placed is what will be decided by the learned single judge.
The rules of 2018 mandates
My lord.
that the incumbent should have a B.Ed degree.
True. Those who are appointed after 2018, persons who come into the post of a headmaster prior to 2018, is it an argument that they were required to have that qualification? If not, if that was not the argument made before the learned single judge, in my humble submission, if that was not the argument made before the learned single judge, persons who were appointed as headmasters or provincialized as headmasters prior to 18 would not have that requirement. Simply because the rule of 2018 has come in prospectively, persons who were already appointed as headmasters, would they lose their headmastership? They would not. They would continue to be headmasters. Only persons who would now after 18 be appointed as a headmaster would require that B.Ed qualification. Person who was provincialized or appointed as a headmaster prior to 18.
2018, the 2011 was there.
B.Ed was not a requirement. That was not the argument before the learned single judge. What I'm trying to project is a case was presented before the learned single judge. Learned single judge decides on the materials placed before them. These grounds find no mention in the order of the learned single judge, presumably not argued before him. If that be so, can a fault be found with the orders passed by the learned single judge? The requirement of B.Ed as of date has been dealt with at paragraph 16. When the provincialization took place, he was taken in as a regular headmaster. Shiksha Kshetra scheme says that a regular headmaster will be the headmaster in the amalgamated
That
school.
is only a scheme.
That is how he has become the headmaster of this particular school.
Now we have to consider that area.
Of course, the matter can be admitted, my lord, but at this stage,
What is it? No, rules provide that he requires a B.Ed degree. It doesn't have. 2011 rule says you should acquire within 5 years. Of course, it has been declared null and void. But then those who will. Oh. I don't know, what is your view? What is your view? No. Or just say, we just say that status quo.
It's over.
Without.
my humble submission will matter. If it requires consideration, let it be admitted, let it come out after the vacations. My learned friend is perhaps appearing for the private respondent. That is what she has been telling me. She doesn't have a copy of the same episode.
My my only reply to my learned friend Rashid that prior to 2018, the rule was 2003, and under this rule 2003, rule 14.4, it mandated that B.Ed is a mandatory qualification. Even
was never
since
administrated to the
1982,
legislators. That
I
is
am
the
not
whole
saying about this 2003, the 1982 rules also, the prior to this 2003 rule, Assam Secondary Division Provincialized Service 1982 was in force. So when that particular act was in force, when these petitioners were given the charge of inside at the census stage, at that time also B.Ed qualification was required, and that was not considered. Now, Lordship, the authority, by way of the merger of the order, they are trying to fill up the post which was held vacant since 2015. That cannot be do so, Lordship. The order Lordship cannot override the requirement of the statutory rules. So this may be stayed, Lordship.
Stop. R. Majumdar, Learned Standing Council, School Education Department. Appears for respondents, 1, 2, and 3.
Yes, yes. 1, 2, 3.
1, 2, and 3.
And
And MS,
Esther Khalifa on behalf of MS KDB.
MS,
KDB.
Lordship, they have not filed any caveat. Notice also yet to be issued. So,
have you filed a caveat?
no caveat is there.
Then we'll issue notice.
Yes. Notice will be issued in respect of version of 4.
Appellant to take steps for service of notice on response number 4 by registered proceeding within 1 week from today. Stop. List the matter after 4 weeks. Till the next returnable date, parties are directed to maintain status quo as on today.
The order may be stayed.
We are saying to parties to maintain status quo as on today. If you have handed over charge, you have handed over charge. If you have not.
Obliged.
Timing item 13.
Item 13. Whatever it has come. Where's the NIT?
My lord, NIT that in the affidavit, my lord, since Justice Goswami is there, my lord, may I just place the facts or for 5 minutes? Earlier, my lord, your lordship has heard the matter. My lord, page 51, your lordship can listen. This is dated, my lord, 2/5/22. 2/5/20. Here, my lord, this is for that page 52 Singra bill. Singra bill, tenders were submitted. First, second, and third bidders, my lord, withdrawn. So I was the fourth bidder. So normally, my lord, the offer should have been made to me, but they have withdrawn the tender. Your lordship may kindly note this, my lord. They have withdrawn the tender. I should have been given first, second, third bidder withdrawn. Whatever bid, my lord, they should have given to me. Now, on page 85, your lordship will kindly see, this is again same tender, date is 11/8/22. In respect of the same, my lord, bill, Singra bill, page 86, I have shown. Here, my lord, we file the writ in the High Court. And page 93 is the order. By Honorable Justice Suman Sham, page 93. Order is 7/9/22. Last sentence, page 94. On the request of Mr. Majumdar, this matter is directed to be listed again on so and so as to enable him an opportunity to obtain instruction in the matter and apprise this court. So this was the position, 94. Then thereafter, my lord, page 95, we have withdrawn the rate because the condition is there. Page 95, my lord.
page 96. It starts from Mr. R. Mojumdar, Learned Counsel for the petitioner, submits that in view of the new condition imposed in the tender, restraining allotment of the fishery to a particular person to only one fishery at a time, he be granted leave to withdraw this petition with a liberty to file afresh. So this with this liberty, my lord, this petition was withdrawn. Then, my lord, another writ petition, that writ petition was filed, page 97. Order is at page 98. Notice was given, page 99, my lord. Notice was given, last sentence, page 99. The prayer will be considered, my lord, regarding stay, will be considered after service of notice upon the remaining respondents. So at that period of time, my lord, they have withdrawn the tender, they have issued another tender. So another tender was issued, we have page 100, my lord. Page 100 and same condition, my lord, as it is at page 103. My lord, these conditions I'll just read, my lord, for the sake of benefit of, my lord, the court. If a bidder society submits tenders for different fishery, but only one fishery will be settled, considering the interest of actual fishermen community and also considering highest bid value of the bidder. Second, my lord, as per condition number 2.8, if the highest responsive bidder has withdrawn as per condition number so and so, this highest bidder can be given settlement at the rate offered by the first highest bidder. So these two conditions, again, my lord, same conditions, which was there earlier, and we have challenged this. Now, on this, my lord, your lordship has passed that IA, my lord, that order I have given it in loose, my lord, 3922. 3922, my lord. Amatu kota. Amatu. Honorable Justice S. Medhi, my lord. 3922. Has your lordship got it, man? Last sentence will do, my lord. To balance the equities, it is directed in the interim the petitioner be allowed to offer its bid in respect of the present tender notice, and the same should be considered at par along with others. My lord, because we, my lord, we were given one, my lord, bill that we have stated here on the tender, my lord, and therefore Bahua Taba bill on 16/7/22, and because of this, my lord, we become ineligible because of the condition in the tender, because we have been settled with one bill. If you are given one bill, you will not be given another bill, even if you are first highest tender. And other condition is that if the first, second bidder withdraws, then the third bidder, if I happen to be the third bidder, they will not give settlement. So these two conditions were challenged. Well, this is the third writ petition, and the interim order is this. It is directed that in the interim, the petitioner be allowed to offer his bid in respect of the present retender notice, and the same should be considered at par along with others. And the bid opening date was, my lord, 7/10/22. 7/2. That your lordship will find. Page 100, my lord. Page 100. Second paragraph. The last date of submission of the tender is 7/10/22 up to 2 p.m. and the tenders will be open on the same day. And the interim order passed by this court is 39/22. We submitted, and on the basis of the interim order passed by this court, we submitted tender. They are supposed to open it on 7/10/22. However, this interim order continued only up to June 22. So therefore, we filed an IA. In IA, my lord, this order was passed. Page 24. Huh?
Page
24, my lord. At page 25. Because they should have opened the tender on the basis of the interim order, we submitted bid. So accordingly, their date of opening of the tender is within the interim order passed by this court. heard Mr. So-and-so counsel who submits that IA arising out of this writ petition has been filed seeking extension of the interim order dated so-and-so, which may be considered by this court. Responding to the above, Sharma Standing Counsel AFDC submits that after the interim order was vacated, the tender process went ahead. But all the bidders quoting higher price have declined the settlement order, as a result of which the authorities are now contemplating to go for a fresh NIT. However, on a pointed query made by this court as to whether since no other bidder is willing to accept the fishery on lease, the AFDC authorities would still be open to settling the fishery with the petitioner at a mutually agreeable rate. The learned counsel for both the sides have sought time till so-and-so to come up with this instruction. In view of the above, let this writ petition be listed again on so-and-so along with so-and-so. IA is also there. Mr. Sharma to produce written instructions from his clients on the next date fixed along with the relevant records. Now, next date, my lord, at page 26. He says because of the division bench order passed by the court, there cannot be, my lord, any settlement on the basis of any understanding. At page 29. By the order dated so-and-so, query was raised before the AFDC authorities as to whether they would be open to settle the fishery in, I'm reading page 29, my lord. In question with the petitioner at a mutually agreeable rate at the circumstances that the three higher bidders in the tender process have refused to accept the bid settlement. In the circumstances where the higher bidders have refused to accept the settlement, there does not appear to be any discernible bar under the law to negotiate with the tenderer who had submitted a lower rate and to make a settlement at some higher mutually agreeable rate. But in response thereof, the managing director IFDC had made a communication dated 9/11/23 that a mutually agreeable rate cannot be made in view of the full bench judgment in Haria Dublong Mean Samavai Samiti Limited, and accordingly the judgment rendered by the full bench is also produced before the court, and then reliance is placed on paragraph 26(2) of the said judgment of the full bench, wherein it is provided that proviso to rule 12 of the fishery rules would have no application to AFDC. Making a mutually agreeable settlement with a tenderer with a lower bidder in the circumstance where the higher bidders have refused the settlement offer, and making direct settlement under Rule 12 of the Assam fishery rules are entirely two different and unconnected aspects. The managing director be put to notice of the inapplicability of the full bench judgment as indicated above, and to respond to a more appropriate manner to the query of the court dated 6/11/23. So at this instance, my lord, after this, they say, my lord, we are withdrawing the tender. So therefore, this interim order was passed. Page 114. My lord, the petitioner was not even given a copy of that withdrawal order, my lord. They said we are going to withdraw. Page 114, my lord. Today, when the matter has been taken up, Mr. P. Sharma, the learned standing counsel appearing on behalf of the AFDC, submits on instructions that the AFDC is not going ahead with the said tender and would be issuing a fresh tender. In that regard, and instructions have been placed before this court, which is kept on record and marked with the letter X. This I did not get it, my lord. In that view of the matter, as respondent authorities are not going ahead with the said tender, my lord, this does not answer to the queries raised by the court. Your lordship has, my lord, I have gone through two orders I have passed by Honorable Justice Suman Sham and Honorable Justice Bujo Bura, my lord. Two orders I have shown. These two, the query has not been answered. So if they, my lord, this will be my fourth writ petition if on the same subject matter. During the pendency of the case, my lord, without the leave of the court, they are trying to withdraw the writ petition and bringing the same tender notice with same conditions. This affidavit which they have filed, my lord, this affidavit, my lord, they have annexed conditions with same conditions. Here that I will show, my lord, page 142. They cannot be allowed to play hide and seek with the court when the matter is, my lord, normally when the matter is pending before the court, whatever we wish to do, we take liberty from the court. Now that we are going to withdraw, therefore, the court has to give permission, my lord. page 142, my lord. 3.8. 3.8. One person, one society can participate in all the tender of the corporation, but settlement will be given to only one tenderer, one society in the interest of the actual fisherman, and in no case settlement will be given to more than one tenderer, one society. These conditions will be applicable only to the present settlement holder only. So therefore, if I have a tender, I have a fishery, my lord, I will not be able to participate. I already have a settlement with the same, because on the basis of my tender, because they have given me a my lord, settlement on the basis of this. That Tawa fishery, my lord, I state Bohua Tawa bill 16,722, on the basis of the tender, I got it, being the highest bidder. Now, second, my lord, 11, the highest 11.1. The page 142. Huh? The highest valid bidder will be accepted as per clause 6 of the NIT after examining document. Furthermore, less amount of revenue will not be accepted as fixed by the corporation in spite of the correctness of documents as per clause 6. Moreover, retender will be issued in those cases where lesser rate is quoted by the tenderer than the minimum rate. That is all right. Now, 12. In case the first bidder denied or cancelled after being selected as per condition 3.8 and 11.1, 11.1 I have read, then offer of settlement will be issued to the second bidder at the rate of the first bidder. So in that case, if the second bidder refuses to accept the settlement, then his earnest money will not be forfeited and the corporation reserves the right to go for retender. So this is the conditions which I have challenged in earlier writ petition. They have brought in the same conditions, my lord, during the pendency of the case. My lord, this is not done, my lord. During the where the interim order was there, and during the, my lord, in the tender notice it was there, my lord, on 7/10/22, my lord, they are going to open the tender. At that time, tender was the condition, interim order was in operation. Interim order goes, my lord, in the month of June, because we could not, my lord, court issued rule, my lord, we said, my lord, interim order should continue, but somehow it did not come. It is our fault only. So, but therefore we have filed an IA. So accordingly, my lord, the court was considering the IA and some questions were posed. So during the posing of the questions, my lord, they say, my lord, we are withdrawing the tender and we are being in the same conditions. This is, my lord, not done, my lord. This is during the pendency of the case, my lord. This should not have been done. They should, if they have withdrawn the order, my lord, they should have given to the petitioner for the purpose of allowing him to amend the petition. So therefore, I humbly submit, my lord, your lordship will kindly interfere with the order of the order passed by the learned single judge and direct the, my lord, continuance of the interim order, or, my lord, allow us to amend the writ petition on the basis of the conditions which they have now imposed. Fourth writ petition, my lord, and fourth tender notice. These two conditions which you have challenged, there should have been some answer from the court. And without that, my lord, they cannot be allowed to withdraw the writ petition and again, my lord, come up with the same tender with same conditions. So that is not, that doesn't answer, because it is, I think, in the interest of justice, my lord. Justice demands that the condition challenged by the petitioner
Our lordship, there is no tender. Actually, the fact is that initially when tender was, we have opened the tender, we have completed the formalities, we have finalized it. And after that, we went for fresh tender, lordship. And in fresh tender, lordship, there is a minor difference in this new clause, lordship. Here we have imposed that it will be applicable to the present settlement holder. It will not, in their earlier order, lordship, it is only for a bidder, lordship. 4.5. If a bidder society submits tender, it is only for the only the NIT who participated in the tender process will be applicable, that he will not be offered two bills. And here we have generalized it. Here we have generalized it that it will be no settlement holder, Lordship. It is a tender, new tender, Lordship, new NIT. Lordship, they have the liberty to go for a challenging afresh in the single bench. If they go get a favorable order, that's I don't have any objection, Lordship. Here, Lordship, there is nothing live in the tender process. We have completed the tender process. Now there is nothing. As because an interim order was vacated, they have not continued. We have completed the tender process. We waited for more than one and a half years, Lordship. The case was pending. This bill was pending, Lordship. This case was pending, and after that we open it. Lordship, we are losing revenue, Lordship. Lordship, we are not being able to settle it for only one.
Thus, I think matter has become infectious.
My lord, that way, my lord, I have already submitted before the court, my lord, earlier. I would not have come before this court. Had there been no, my lord, this interim order, the order which was withdrawn, my lord, that is in violation of the, my lord, process adopted by the court. My lord, process adopted is, my lord, court posed a question, can you do this? So that instructions which they have brought, they said, my lord, we cannot do it because of the division bench of the court. That also court clarified. So their next question answer is they are to answer whether, my lord, the negotiation can be done with the petitioner.
After that, they withdrew it.
No, but can they be allowed to withdraw and bring the tender with the same condition, my lord? So now I'll have to file a fourth read petition challenging the same condition.
Some
Same
conditions
condition.
are, there's a difference in the
No
conditions.
difference.
There's
My lord, your lordship will kindly see page 142 same. If I am a settlement holder, I cannot come and my lord, file tender. Same thing, my lord. And if I am the, my lord, second highest bidder, I will have to take it at the rate of the first, the highest bidder, if the first highest bidder would do. Same condition, my lord. I find, my lord, there is no difference. So therefore, my lord, what happens, my lord, if they should have given me the copy of the tender, my lord, which they are trying to withdraw for the purpose of allowing me to file amendment petition. But during that after the order passed by this court, my lord, Honorable Justice Suman Sham and Honorable Justice Bujo Burua, that petition, my lord, they should have given me, my lord, whatever they wanted to do, they should have filed an affidavit for the purpose of allowing that we are going to withdraw. Then I could have asked, what is whether the question can be posed from the court also. Where are you putting the same conditions? If they put the same conditions, my lord, your honorable court would not have allowed to withdraw the tender, because these two live issues are there before the court, whether, my lord, the tenderer can participate or not, my lord. These are two important questions, my lord, allowing this petitioner to file fourth read petition. Otherwise, it becomes infractions. I understand, my lord, during the proceedings, whether their conduct is good, they're allowing them to withdraw because during the proceedings of the matter before the court, and the manner in which the honorable court posed questions. It is not done, my lord. My lord, normally, when the matter is there before the court, my lord, if I want to withdraw a read petitions or withdraw a tender process, the impugn order, we take permission from the court, my lord. It is not done in this manner. Fourth read petitions they have filed. My lord, earlier they have not settled, then they have withdrawn. Again, with the same conditions, they have issued the same tender notice. Again, during the process of this court case, my lord, when the honorable court posed questions, they come and say, my lord, we are withdrawing. Then the next question should have been, are you putting the same conditions? So I pray, my lord, your lordship will, while interfering with the order passed by the London Single
We
Judge.
don't think we can interfere with the order. The matter has become infractious. That's what we have.
That is there, my lord, but
Then
then we will have to file another read petition, my lord.
That's what
This will be a fourth read petition. sir.
There's no. You can agitate before the read court.
That I can do it, but whether the conduct of the respondent authorities, whether it is good, before during the continuance of the matter before the court, they said, we are withdrawing the tender without answering the question posed by the court. That is not fair, And this will be the third time they have withdrawn the matter and they are coming back with the same conditions. And that is how they are not allowing the court to decide the matter. Court, the question before the court was two questions. Whether
That we know, that we know. But then in the order, it's already there.
it is there, it is there.
It's relevant.
It is there, it is there. I would not have come. Only because of the conduct before the learned single judge, the manner in which they were allowed to withdraw. Otherwise, I understand, I would not have allowed, advised the client to come before the court. It is because of the at the extreme level where we are before the court.
You can challenge the tender notice.
Your lordship may have observed it. Your lordship may observe. Same conditions have been put, we can challenge it. I was thinking, your lordship
No,
will
we
allow.
are not making any observations. If that is observed, then it will have an impact on the your writ
Single
petition.
judge,
Yeah. So we don't want to make any observation. We can just say that the matter has become infructuous. Liberty is given in view of the tender notice. Liberty is granted to you to approach the appropriate form in terms of order 23.
Only if your lordship is not interfering, this order will do.
Then should I record that you are saying that it is infructuous? No. It is better.
It is
Mr. VT does then.
in view of the tender notice and the condition provided.
Submits. Learned senior counsel assisted by MS
R Deca.
R data for the appellant submits that in view of the tender notice dated. Now, what date is this tender notice? The vernacular.
Mr. Sharma, the tender notice dated 9/12/23.
Is it reflected anywhere in the vernacular?
No lordship, in the vernacular, no lordship, in the affidavit, it is. Paragraph. Four lordship. In the earlier.
That in view of the tender notice dated tender notice.
No, 9/11/20.
Which was published in the Assam Tribune on 9/11/2023. The matter has become infructuous. However, seeks liberty to approach the appropriate forum to challenge the said tender notice if so advised. Stop. Accordingly, this writ appeal is disposed of as infructuous with liberty as per.
No bar for the petitioner to participate also, my lord. But they are opening on 26. They are opening on 26. And they have given the conditions just today. Earlier also in the notice, my lord, their condition was not there.
Court is
Yeah,
open.
we'll have to find.
And 14. All right. Yes.
Please, your lordships. This case is relating to the impugn order. Your lordship will find.
Lordship, before my learned friend starts, lordship, the reason of his withdrawing the earlier writ petition was not rectified, lordship. Writ appeal, lordship. In the grounds part, lordship.
What ground?
Lordship, page number 21, Lordship. Here, Lordship, here for the impugned judgment and order dated so and so is arbitrary, unfair, illegal, abuse of power, high-handed manner, and not decided in the matter applying. He is attacking the court, Lordship. That part he undertakes before your honor.
Yes, last occasion you wanted to amend this.
Earlier he
I have a strike of that part, your lordship.
Where?
Earlier, your lordship.
How can you strike it off? How can you strike it off? Unless you file an IA.
Arbit.
No, earlier, my lord, he withdrawn the petition.
The
Because
appeal was withdrawn.
Writ
the
appeal was
appeal was withdrawn.
And this is the second time.
Second time, my lord, but no change has been made. That is he wanted.
No,
to
sense he made, your lordship. Earlier, there is a malified word. I have struck off that order. Yeah, that word,
What
your
is
lordship.
this abuse of power, high-handed manner? Applying judicious mind.
My lord, in fact, my
Let us to strike off this, my lord. your
How
lordship.
can you strike it off just like?
no, my lord, repeatedly, my lord, what happened here in this case, his case was dismissed, the petition was dismissed on the ground of locus. And locus, my lord, he did not answer. Even he was given time to, my lord, in line of single judge, my lord. He did not answer on locus, my lord. What is his locus then? He is not taking part in the tender process, my lord. He was the lessee for the year 2011 to 2019. He was his society, not he. His personal capacity came before this honorable court. So he was the lessee from 11 to 2019. So he did not participate in the tender process, which was started in 2023, my lord. 20, my lord. So, my lord, he got extension up to 19, my lord. And my lord, he is a defaulter. So that's why he is not, his society cannot join in the, my lord, tender process. So after, my lord, when tender process was issued, there are more than four tender participate. I was the highest tender. I was allotted the settlement. So after taking charge, took charge of that particular fishery, my lord, after 5 months, he had a petition stating that the person who is settled with, my lord, he is a member of the another society. That is his case. But he is not, he is unable to, my lord, satisfy the court regarding locus. So what is his locus standing? Because you are not taking part in the tender process. So since you are not taking part, that's why no and fundamental right has been impinged. That is the finding of the learned trial judge, learned single judge, my lord. Now, my lord, hearing this writ appeal, not a single line regarding his locus standi he has taken point, my lord. Only, my lord, he is attacking the court. Your lordship, kindly see, my lord, very fast, my lord, there is a gown here, my lord, my learned fan laid, my lord, that the impugned judgment and order dated 26/9/2020 is arbitrary, unfair, illegal, abuse of power, high-handed manner, not decided the matter applying the judicious mind. That is the first ground. Second ground, for the impugned judgment and order violating the Article 14, 16, 21 Constitution of India as well as the legal right of the appellant petitioner by dismissing the writ appeal so and so. Fourth, third, my lord, for the impugned judgment and order has been violated. That is 14 so and so tender notice tender notification dated so and so issued by the managing director of Assam Fishery Development Corporation and Limited, allowing the respondent number 6 Nabokumar Das alias Nabokumar Das, who is in the shareholder of a custodian society. For that the learned single judge had not given any appellant petitioner to reasonable opportunity to defend the case by submitting the order of the honorable court dated so and so, so and so. That I don't know, my lord, that hearing took place in the 3 days, my lord. He has filed a affidavit in reply to my affidavit. Also, additional affidavit also he has been filed, my lord. But ground number 5, your lordship, kindly see. For that the appellant petitioner paid for submission of the reply, WPC was not considered by another single judge. My lord, this directly attack on the single judge that he has not given a opportunity to file appeal reply. In fact, he has filed reply not once, twice. But what is the ground, my lord, taken regarding locus standi, my lord? That this is the ground I have taken, my lord. That because of this, my lord, I have a locus. There is no ground taken in the appeal, my lord. That's why it was pointed out in the earlier round of, my lord, earlier edit appeal, my lord, which was his withdrawn. But same ground again, my lord. So that's why I'm pointing out. So locus was clearly, my lord, only on the ground of locus standi he has moved. So, my lord, there is nothing to interfere with the learned single judge order, my lord.
No, my lord, your lordship will find regarding a locus study, your lordship, I have one citation, your lordship.
We're not
2022
talking about the citations, we're taking
My
about the
lord.
grounds taken by you. Whether you have taken any.
grounds, if it is, my lord, then I may be allowed to struck off this, my lord. I shall, by filing I shall struck off this, your lordship. Allow me to file,
Strike out what?
my lord.
Strike out what?
Last ground, your lordship, for the impugned judgment and order dated so and so arbitrary, unfair, illegal, abuse of power, high-handed manner, and not decided the matter applying the judicious mind. I shall struck off by filing a IA, your
Supposing we
lord,
allow you to strike this off,
my lord.
where is the ground for locus?
Locus standi, your lordship will find, because earlier the appellant has filed a writ petition, your lordship. They are in that order, your lordship, the appellant has authority, appellant has submitted a representation, your lordship, before the respondent, your lordship. But that representation, the honorable will pass an order to dispose the representation. But that representation not disposed by the
I'm not talking about any representation. I'm talking about your locus in the present writ appeal.
my lord. I have the locus because your lordship will sin.
Have you taken a ground?
May I read my ground, your
We have
lordship?
read it. We have read it.
For that the impugned judgment
We
and
have
order,
already read it.
my lord.
Mr. Counsel, kindly point out from the 11 grounds that you have taken, which
My-
is the ground pertaining to locus. Just point that out.
Exactly, that is the case.
He doesn't have. It's not there. So what do you want to do? This is your second writ appeal.
My lord.
That too also
No,
time,
allow-
but that point also I am not going to take that, my lord. Second one is time, but. But my lord,
You lordship,
ground number 8,
you
my lord, your
lordship,
lordship kindly
you
see,
lordship
very-
kindly take it after vacation, your lordship, I will satisfy your lordship.
No. We are giving you one option. You either withdraw or dismiss.
My and liberty to give and file a press, your lordship.
First writ appeal.
No, because there will be there is a merits, your lordship, in the cases, your lordship, because they are impersonated the cases, your lordship. They are,
That we don't know. That we don't know.
my lord, the matter, your lordship, but
It is content.
they have violated the
Mr. R.M. Chowdhury, alternate counsel for the appellant. Press for withdrawal of this writ appeal with liberty to file a petition. Mr. Anand and a senior counsel, appears for respondent number
6, my lord.
6. Mr. P. Sharma, and standing counsel, AFTC, appears for respondent.
must.
And that's one for, you said it clearly. Writ petition is, writ appeal is accordingly dismissed on withdrawal with liberty as spread. Next time, we are going to
My lord,
impose pause.
must.
Item 15 for orders.
IA, what is this IA? In view of the order passed in the manner writ appeal. ISO. Dispose.
15.
Please, your lordship, my lord, this matter relates to the settlement of fishery, my lord. Here we have challenged the,
Respondent for.
yes, we have taken steps by Dusty Service as well as, my lord, registered AD, my lord. Twice we have taken steps.
Have you filed your affidavit
Yes, my lord.
with regard to Dusty?
Yes, my lord. But after that also we have taken steps again, my lord.
When did you take steps on respondent for?
Once, my lord, on by Dusty, my lord. By Dusty,
Dusty was not accepted by this court.
yes, my lord. Subsequently, we have again taken steps, my lord. It is reflected in the office note, my lord.
15/12.
Yes. The date is not, my lord. The date of taking steps, my lord, it is reflected in the office note.
It has been returned not found.
Yes, my lord.
RTS.
So we may be allowed to take fresh steps by Dusty again, my.
But this time you'll have to serve on the proper address.
Yes, my lord.
Yes. MS SP Chowdhury. Then the council for the applicant. Praise for taking first steps for service of notice on respondent number 4 by Dusty Service to the registry of this court. Within a period of
My lord, 1 week.
1 week from today. Stop. Praise a lot. Drafter, comma, the appellant shall file an affidavit to that effect. Stop. List. the
After
matter
vacation.
After the. List the matter on 24th January.
I'm referring for 1 to 3.
Mr. N. does so.
Yeah, I am for the respondent number 1.
Who's the Pichi Fugan? Where's Pichi Fugan? Why is it coming for orders?
60. Maybe 2.
Who affairs for respondent 4? If none appears for the appellant. Mr.
H.J. Tamuli.
A.
H, my lord.
H. Z. Tamuli. Learned counsel appears for response number
One.
Stop. List after
Lordship, if possible, kindly fix the matter for admission on 5th of January.
list down. Not 5th. 8th January.
Obliged, my duly obliged.
17.
Wait, please, Your Lordship. Lordship, before presenting my appeal, Lordship on 15 have directed me to present my IA copy to the other side. Evidently, I could not serve that, my lord, but today morning I have served it. So if he does not object to, I may place my IA
Industries?
for industries, my lord.
No, I'm for one, my
Who appears for the industries department?
industry.
Azir Afiqa Pol. Yes, my lord, my IA is for condonation of delay of 153 days.
Equality industry.
Volume.
My lord, I was only able to serve this copy this morning.
Maybe because his name is not reflected.
Probably, my lord.
Let it come some other day reflecting his name.
Otherwise, copies are served. I can present my
First,
case.
Mr. J. Singh.
J. Singh, my lord.
Learned counsel for the applicant. Registry is directed to reflect the name of the Learned Standing Counsel Industries Department on the cost list. And list the matter on 5th January.
Earlier, please.
I'm appearing and thus for one. 18.
Well, this is an application for condonation of delay in preparing the appeal. 171 days delay is there. In similar matter, Lordship yesterday has issued notice. Here,
Mr. D. Nath, the next senior government advocate for the appellants, isn't it?
appellant, my lord.
Stop. You want to take service only on the OP one?
Only OP1, and we'll take by Dusty.
Issue notice. The appellant shall take steps for service of notice on the opposite party number 1 by dusty service to the register of this court. Within a period of
Lordship, within 1 week we'll take.
1 week. List the matter again on. When are the other cases listed?
Lordship is after 2 weeks, returnable in 2 weeks. After the vacation, it will come. In a days. In a 10 month.
Was it only 2 weeks? No date fixed.
No date fix. No date fixed.
Just up to 3 weeks.
No, item number 20 and 21, they're same. They're similar. They
Same OP1.
OP1. 173 days delay in item 20 and 171 in item 21.
Item 26 from supplementary list.
May I please, your lordship? In this matter, lordship was directed the government of Arunachal Pradesh to take instruction whether the respondent was paid salary or not, lordship.
I have received a minor copy of the letter issued by the department, my lord. Yesterday, my lord. No, it is, my lord, sure, once he is there, my lord, action will take very immediately. Matter is otherwise fixed on 3rd of January, my lord. Today it was only.
It was being prepared, my lord, when we came before your lordship last time, my lord. Now they have given the undertaking that it will be paid, my lord, within.
So the otherwise, my lord, unmarried, matter is fixed on 3rd of January.
Is it?
Yes,
Lord,
last.
yes. Only yesterday, lord.
Only as regards the salary, it was fixed today.
Third, Mr. R.P. Sharma, senior counsel, assisted by
S. Dhingia.
S. Dingyal and counsel for the appellants.
No, Lordship.
No.
In appeal and Lordship, I am for
Oh, sorry. Heard Mr.
N.K. Sharma, Lordship.
N.K. Sharma, learned counsel for the appellants. Stop. Cancel the. Mr. Vidhi Goswami, learned additional advocate general. Aaron Azhar, assisted by A. Chandra, learned additional senior government advocate, has produced a communication dated 18 December 2023, written by the Undersecretary PWD, Government of Arunachal Pradesh, wherein it is stated that the pay and allowances in respect of the respondent number three. Public Shri Hagi Tajang, Executive Engineer, with effect from September 2023 are being prepared and will be paid to him within December 2023. Stop. The communication dated 18 December 2023 is placed on record. Stop. List these matters on 3rd of January.
Lordship, interim order is there in this matter.
Interim order passed.
Deeply
Let them not delay this time in filing AVT because it is otherwise.
Lordship, otherwise, we have filed our affidavit in reply in writ appeal, Lordship.
In the IA, we
IA.
have time yesterday to file in the IA. Otherwise, I'll place the matter.
Deeply obliged, Lordship.
27.
Lord, may I please, Lordship? For this interlocutory application, we have filed for stay of the judgment dated 31/2023. Lord.
1 minute.
Lordship. Lord, the judgment, Lordship, will find at page 26, Lord,
Of the IA?
of the IA. Well, here a policy decision of the government as regard the appointment on compassionate ground, Lord, that has been challenged. A particular clause has been challenged. If Lordship kindly comes to page 34, Lord, there Lordship will find at paragraph 12 the Lordship the Honorable Court has noted the issue, Lord, whether clause 1 of the office memorandum dated 1/6/2015 insofar as it deprives the dependent of the government officials who die in harness having less than 3 years of service is violative of Article 14 of the Constitution. But ultimately, this Honorable Court has decided, and the learned single judge has decided, that this is to be violative of the Article 14 and accordingly struck down. But against this writ petition, the order passed in the writ petition and batch of the cases, we have preferred the appeal. The appeal, the delay has already been condoned. I have annexed the order at page 59. And at page 59, Lordship has condoned the delay in preferring the appeal. And now the appeal is pending before Lordship. During pendency of the appeal, if the judgment is not stayed and the direction of the Honorable Court is required to be executed, the government is facing difficulties in that, because the direction of the Honorable Court is to hold the DPC and excluding that particular clause to consider the cases of the writ petition as well. Considering the pendency of the writ appeal, I pray that this till the disposal of this writ appeal, the judgment operation of the judgment will be stayed.
Who appears on the other side?
The service is complete. Lordship, the note, the office note says, we have taken dusty steps. Nobody appeared in the matter.
In the IA?
In the IA and the writ appeal. In the writ appeal also. Writ appeal record is there, Lord. At page 59 in the IA, Lordship will find that I'm reading the order, Lord, for a moment. Page 59 in the IA. The registry has reported that service has been effected on the contesting respondent number 1. The other respondents are components of the state government. Thus, service is presumed to be completed. The instant interrogatory application has been filed seeking condonation of delay of 28 days, occasioned in preferring the connected writ appeal against the judgment and order dated 31/2023, passed by the learned single bench in WPC number 3245 of
No,
2019.
this is on the condonation.
This is on the condonation.
But even on the IA, we have to issue some notice. Let us see.
But
At least they should make some appearance. If they don't make the appearance, then you can pass on appropriate orders. But then this IA will have to hear the writ petitioner.
But the writ appeal thereafter has been listed it is pending before Lordship. Ultimately, by this order, Lordship has said the registration number and number, the connected retable and
No,
list
no,
the same.
no.
It
That-
is
that-
listed.
That's fine.
Lordship.
That was because your continuation was
Yes,
allowed.
yes, yes,
After continuation, retable was numbered
yes, yes.
and it has come up.
Yes, it has come out.
Now in this present IA, you are filing it fresh.
We have filed a fresh for stay of the.
So we have to issue a notice on the IA.
Lordship. But in
But they
in the
not-
in the meantime, during pendency of this, Lord, kindly till the returnable date, Lordship.
No, I'm not saying it. But they not done a senior government advocate for the applicants. By this application. The applicants are praying for stay of suspension of the judgment order dated 31/2023, passed by the learned single judge in WBC number 3245/2019. Stop. Issue notice. Applicants to take steps for.
Sir, we'll again
on
take
the-
does the steps.
On the opposite party number one.
One, Lord.
By Dusty Service
Justice, sir. We'll take.
to the register of this court.
Lordship,
Within a period of
within a period of 1 week, we'll take. Lordship may kindly fix a date until the returnable date. Otherwise, the operation of the order is the effective.
the applicant shall file an affidavit to that effect.
But the
We'll list it on fifth.
till then, Lordship may kindly observe.
No,
Till
not now. Only after the notice is served or till we get a confirmation.
Lordship was fixed on 5th.
Fifth.
Lordship. Hold on.
Four. And one. Oh, do you want to take a break? No. Oh, this is the one which we said at 2 o'clock. Just see for what reason this, for what reason was it postponed to 2? Why did we say 2?
But I think affidavit was, did you call for the affidavit that time? The affidavit was not, it will like.
And that one is over. Councils are here. Okay, then call hearing. You want to take a break? You can take a break. After 5 minutes.
Hearing, it will take some time.
You will have to be here.
He has
Fine.
given.
Date may be fixed, man.
Okay, heard Mr. AI Udin and on request made by Ms. Harvey Boral and the government advocate.
On 25th, man.
This matter on 25th.
25th.
Okay.
I am for respondent number 6.
MS
A David.
A David and the council appears for response.
Time of life.
Item 24.
Item 24. Item 24.
Oh, copy was not served.
The FTC copy. Break from our single benches and come back.
No one is from the other side. Can it be taken up to?
Mr. Nath, item 24. Can you also ask your junior to inform the AFTC council?
Department also.
My lord, meanwhile, can I apprise your lordships about the brief fact, my lord?
Mr. Caveat?
Yes, that's what. Yes, they are here. We informed them it will be 2 o'clock, but now they're there. I think my junior has gone to there to call him. Just be fact in the meantime, let me place, my lord. In 2013, an NIT was issued, pursuant to which the private responder 4 was granted settlement. Rejecting our claim, we came before the single bench. Our claim was rejected, writ petition rejected. Then we came before the writ appeal, my lord, by the writ appeal. In the writ appeal, the Honorable Division Bench was pleased to set aside this order in favor, passed in favor of the responder 4, and also impose the cost of rupees 4,000 to the government. Because there's a direction that as a Maimal community, we are entitled. Government rejected that claim. That was settled by Supreme Court, my lord. Government rejected our claim. That's why cost was imposed on the respondent. Subsequently, for 7 years, from 2016 to 5/7/23, last, my lord, it was settled with us. Now the new issue cropped up. The issue is just before 5/7/23, the entire fishery, out of the entire plot, my lord, 80% fishery was included in the Orang sanctuary, my lord. Now there remain only 20%. So government wrote to the deputy commissioner, you make the assessment about the revenue, how much revenue will be there. And while doing so, it will take some time. So the deputy commissioner issued an order after 5/7/23, that days had passed. That, all right, as a 20% enhancement, you pay the daily wage basis. The sitting lessee was allowed to run, my lord. So we were running, my lord. When we were running the fishery on daily basis, the private respondent approached the government, and the government has issued the impugn order allowing them to operate the fishery at little higher rate, 3,000 rupees, my lord. It was done without any information to us, without a notice to us, my lord. So it came before this honorable court.
Without ascertaining the
Yes.
illegality.
And my lord, we came before the honorable court. Honorable court was pleased to stay the impugn order, my lord. Against the impugn order, my learned friend, they filed an application for vacation of the stay order, my lord. That was allowed, my lord, and the dispute was disposed of, my lord. That's the fact, my lord. Just, my lord, lordship, please come to page number 57, my lord, once. That's the brief fact. It starts, my lord, lordship, kindly, it starts from page number 54, the writ appeal, my lord. 54, my lord.
Lordship, I'd like to pray for a little accommodation, Lordship. Since it was said that the matter will be taken up at 2, I had informed my senior since he had some personal difficulty. You'd be present at 2 o'clock, Lordship. That much of accommodation we require from our side.
KK Mohanta is there, you know?
Yes, KK Mohanto.
KK Mohanta.
Lordship may take up the matter tomorrow also.
Tomorrow.
Yes, Lordship.
Day after tomorrow, Lordship.
Or my lord, lordship is one thing, my lord. At least status quo may be maintained, my lord. in
That may
case.
not be given because
As of yesterday, we have deposited the revenue, my lord, on daily basis.
Lordship,
Yeah. This is-
Legal thing, Lordship.
Lordship, in terms of technicality also, they have not filed another petition for stay. With writ appeals, they need to file stay petition. They have not filed it.
That is not required.
In our high court, that's in Shillong, my lord. We have to file an extra petition, but in our high court, that is, my lord.
It is required.
In Shillong, my lord, in this petition, we have to file an extra petition. I got stuck up that day, my lord. I didn't know I followed this system. The Honorable Justice, thank you, asked me, where is your application? I was a little surprised, my lord.
Okay. But Mr. D not. Senior, M not, then senior counsel. Yes, Mr. DB Vora, then the counsel for the appellants. On request made on behalf of Mr. KK Manda.
Yes, Lordship.
Then the senior counsel appearing for the
Respondent 4.
respond number 4. Is tomorrow?
Lordship.
Tomorrow is what date?
Yeah, for tomorrow maybe.
No, my lord, no, my lord. Tomorrow, my lord. We made mention yesterday. That's why it's listed.
20.
Tomorrow.
Much obliged, Lordship.
Obliged.
Sorry for interruption, Your Lordship. In 1916, Mr. T.J. Pukon appeared. He's the appellant, Your Lordship. He informed me that due to some personal difficulties, he could not able to come to court today. But my presence may be recorded, Your Lordship.
We have already passed orders.
Lordship, it is fixed on, I think, 8/1, Your Lordship.
So,
It is shown absent, Your Lordship. That's why.
okay, on the request made on behalf of PG Fukan and
Our
standing
board,
counsel-
Lordship.
Standing Council, Guwahati University. List on 8. It was
Eight.
fixed on 8.
Yeah. Highly obliged.
Second.
22nd January.
Yes.
May I please? My lord, on behalf of Learned Senior Counsel, Mr. M.Z. David, I beg to mention item number 4. My lord, please, out of session. Finally, matter may adjourn for the day.
On request made on behalf of MZ Ahmed and the council for the petition. List on. Same date, 22nd.
Obliged.
Item 1 for motion.
Well, there is an order, last date. Your Lordship heard the matter on 3 occasions at the motion stage. Then your Lordship did because single your Lordship was not normally sitting, therefore.
So it was released, isn't it?
Released, but I think the appropriate bench again is as per roster, my lord. Again, your Lordship is the appropriate bench perhaps. That's why.
No, it is shown parted again.
Yes. So I am at your Lordship disposal, my lord. I have
No.
Or my lord, matter is urgent also, increment withheld, my lord, that matter, Lordship.
Yes, I know.
Disciplinary proceeding is, let it be before the other, my lord, appropriate bench tomorrow, my lord. If your Lordship is not taking up, but he is here. Sorry, my lord.
No, I can't, I won't take up this. It was kept part heard. I've released it. After releasing again, if I hear it, and this is not the rooster court.
My lord, let it be before any other appropriate bench tomorrow, my lord. Matter, there is urgency also.
Okay. Registry is directed to list this matter. In terms of the order dated 15/12/2023.
Lordship may mention before
On
other,
before
any other bench, other than your Lordship.
Not report as per rooster on 2012.
Tomorrow.
Tomorrow, my lord.
Tomorrow may be difficult.
My lord, it is not yet over 1 o'clock, my lord. Tomorrow it may be listed, my lord. It will be
Let it
listed.
be 21st,
Huh?
day after tomorrow.
Day after tomorrow.
Day after.
Item 2 for admission.
With your lordship, my lords, this matter is a part hard, my lord, because before the single bench, my lord, some other advocates conducting those matter for the government. This is implement part hard proceeds on legs in some other court. My lord,
But already I think I'll release it from.
my lord, lordship.
But J. Bhatwari, let the counsel for the petitioner. Stop. This matter has, this matter is kept part, this matter is released from Parthard. And registry is directed to list this matter before the appropriate court as per rooster.
Lordship, I am appearing for all the respondent,
MS,
MD Bora.
MD Bora Learned Council,
government,
Learned Government Advocate appears on behalf of the respondent.
lord. Deeply obliged,
Magistrate has come.
deeply obliged.